The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. This is Judge Ruth Kraft. I'm the chair of the Employment Law Group at Kirschenbaum & Kirschenbaum. I want to thank you for joining me for this webinar this afternoon. The title of the webinar is Employment Law Pitfalls for Small and Growing Companies. And let me tell you why I decided to focus on that particular issue. The reason is that most companies we know that get into the most trouble in employment law issues are those with between 5 and 50 employees. That fits probably 90% of non-corporate physician practices these days, and many other new and developing companies. I hear all the time from clients that when they call with a problem and I say, well, let me first look at your policy so that I know what's going on, I hear right away, oh, I don't have a policy. Or, and sometimes worse, I hear, well, I have a document that I got it from ADP, or I got it from my brother-in-law and thought that I can't afford to pay a lawyer a couple $1,000s to write these documents. And then I usually say, do you know what your own document says? And then I hear, no, could you tell me what it says? And that's when I know that we are all in for a lot of big-time trouble. Penny wise and pound foolish is the operative word, frankly. One of my favorite stories, I hope the client isn't listening, I don't mean to embarrass someone, is someone showed me an employment manual with a caveat, I'm not spending any money to revise it. I'm just doing corporate work with the firm. And the document referred to maternity and paternity leave pursuant to provincial and federal law. Well, that's great, except for the fact that the United States doesn't have any provinces. The document came from a relative who practices in Toronto. For those of you who don't know, as crazy as our laws are, and if you read my blog, you know that I keep writing because they get crazier by the week between the EEOC and the NLRB and the U.S. Department of Labor. They're all on, on crazy mode these days. Basically, what happens is that in Canada, the rights of the employee are so paramount that it's virtually impossible to fire someone. And so what this doctor had bound himself to by giving this manual out to all of his workers was a full year of maternity and paternity leave with the right to return to the exact same job. Nothing in FMLA goes that far, and FMLA wouldn't have applied to him anyway because he had fewer employees than the minimum. So you should not be giving it away by having poor documentation. It is a complete waste of money. And frankly, for what it was going to cost that particular doctor, I could have written the employment manual probably 10 times over. When you have documentation, documentation should spell out what your practices are and also what your expectations are for your employees. So when we write an employee handbook, we're trying to, one, manage their expectations. How many of your employees think that it's sort of an entitlement to get a raise at the end of every calendar year? Well, if your employee manual says that raises are given when the management decides to do so, or, for example, that you cannot take off a sick day whenever you feel like it, there are protocols for how we allot sick leave, that you can't come in and say, I'd like more than I'm entitled to because I feel like it and pretty please. Then your employees know where they stand. And frankly, you should know where you stand so that when the employee asks the question, the answer should be in your own manual. All you have to do is open it up and take a look, and you should be able to answer basic questions on your own. If you can't do that because your manual doesn't say what it should be saying, the odds are over 50% that you're going to give the wrong answer. And once you've given that wrong answer and the situation escalates and you call me, it's going to be a lot more expensive than giving the right answer to begin with. Employee handbooks can reduce complaints. They can focus employees' complaints. They can set your standards, one of the few ways where you have some control. And they can provide you with defenses. If an employee claims that they've been harassed in the workplace, and you say, well, that's amazing because, first of all, we deny the allegation. Second of all, our manual contains anti-harassment, anti-discrimination language. Third of all, here's proof that we had an in-service which every employee attended on that subject. Well, then you're very far ahead of the game, because those documents can be used in a motion for summary judgment to defeat litigation. I think also, seriously, that when employees know what the limits are because they're spelled out clearly, they will not complain as much. They come to work and they've been given a document, and the document says, this is our vacation policy. This is our policy for when it's 6 degrees out, as it is today in New York. This is our policy as to whether you can take leave you haven't accrued. They know where they stand. Remember also that anything that's written in a handbook and a policy has to work in compliance with federal, state, and city law. As of January 1, if you have more than a certain number of employees in New York City, you are now obligated to give them sick leave. And whether it's paid or unpaid depends on the number of employees in your organization. I fully expect in 2014, one of my predictions, and I'm not a seer, but I can predict that by the end of 2014, you are going to see New York City allowing people to take leave to go to their children's school concerts and parent-teacher conferences. And that will be mandated, and it will not be an event of discipline. If the kid has ADD and the parents call to school a lot of the time, you can't fire them for that, even though it really interferes with running your business. So you need to be aware of all of these things. Everybody who is on my listserv knows all of these things because I write about them every single week. I can't stop writing because the regulation is changing faster than I can write. And literally, employment law is the fastest changing area in New York law, in the United States right now. What happens when somebody decides to do it themselves, write their own manual? Well, I'll tell you what happens. Because the classic mistakes that individuals make in drafting are to create, for example, inadvertent contractual liability, which impairs what we call at-will employment. In the United States, unless you have a contract for a specific term of time that is articulated, all employment in most states is at-will employment. There are some rare exceptions, meaning that the employee can leave you whenever he or she chooses because we don't have involuntary servitude or slavery, but it also means that you can discharge the employee for cause or without cause at any time when you feel it necessary to do so. If you write a manual on your own and it refers to an employment contract that really doesn't exist, or it provides, for example, certain terms, you can turn at-will employment into contractual employment and discover that you're liable for some money. And of course, we do not want you to do that. You can also omit legally mandated policies. Any manual that does not refer to the right of collective action under the National Labor Relations Act is a tainted manual right now. The courts are construing the manual in other significant terms as not being what's called the full integration of the law because you've omitted things that are mandatory. The same for a manual that doesn't have an anti-harassment and anti-discrimination policy. So some manuals refer to things that are outdated or now are illegal, and that's a problem. The biggest issue I see in reading manuals, and unfortunately I see this even when I read manuals that are written by legal counsel but who aren't true employment lawyers, is provisions conflicting with one another. So you read in one page a particular rule, and 10 pages later, there's a different rule that doesn't apply. Let me give you an example of another thing I saw recently in a policy that really gave me pause. The Family Medical Leave Act does not apply to all employers. It only applies to employers having more than a certain number of workers within a 75-mile radius. And it's a little complicated in terms of what if someone works from home and how do you count part-timers, etc. But I saw a manual several weeks ago, and that manual stated that it gave FMLA protection to all of the employees. Now, if you write that in your manual, you just made the Family Medical Leave Act applicable to your workplace. Only this was a workplace that had 3 workers full-time. They were completely exempt from the Family Medical Leave Act. They could no longer claim exemption without rewriting the manual, because by virtue of the manual, they made themselves bound contractually by the terms of FMLA. Don't do that. So if you buy a manual and it happens to come from, for example, ADP or a major company, and they're writing a one-size-fits-all, they are not reviewing this document to say, well, you're too small. That size doesn't fit you, and it's going to expose you to costs, accountability, documentation, and aggravation that you do not otherwise need to deal with. So be careful for that, because, again, that is a huge, huge problem. Another problem that I see all the time is the bigger picture. Small enterprises, enterprises that have 5 to 50 employees, are typically never going to have a dedicated human resources professional, someone who has a degree or certification in human resources, someone who's reading on the changes of the law constantly. And often, supervisors and managers just do not know the state of the law. So even if you have a CEO who's in touch with me, who gets it, if down the food chain there are employees who don't, and they say absolutely the wrong thing, the employer is liable for those acts. We have case law. Recently, the leading case is called Ball State versus Vance. Vance versus Ball State. I'm thinking of the appellate version of it, in which someone in a workplace made racially suggestive and inappropriate remarks to a subordinate / co-worker. And what saved Ball State University's behind was the fact that this person didn't have the power to hire and fire. And so, because the employer wasn't on notice of these remarks, the employer was not held accountable for them. But it could have easily gone the other way. So that part of good employment practices are for all of your supervisory personnel to understand the consequences of the law, understand what will happen if they say something that inadvertently violates the law, and the consequence for you is the employer. So you need to be very, very careful about that. If you have a handbook that is older than 2013, it is probably not worth the paper it's printed on. 80% of it could be great, but the 20% that isn't is going to be very, very damning for you. So you need to review your documentation regularly. Also, when you do have documents like manuals and you distribute them to your workers, it's not enough to just hand them out. Paper trail becomes very crucial. I know that a bunch of you on this call are in physicians' offices, and you have had paper up to your ears. And even if you're not on paper and you're on EHR, and I wish you the best of luck with that, because it's a royal pain, it's horrible, it interferes with the doctor-patient relationship. You have HIPAA, you have OSHA. All these acronyms, the alphabet soup, is so overwhelming that then when I come along and say, wait, there's more, I think everybody wants to crawl under the table, you know, like in a civil defense drill, and pretend that it's not happening. But it is, and it's serious. Now, what if you want to make changes? A client called the other week and said, I discovered that my employees are actually entitled to an absurd amount of vacation because a former owner of the practice was very gracious, and he kept letting them accrue vacation time. And so now they're up to an amount that I want to have. It literally surpassed the entire civil service, and that says a lot. Can we change it? Well, the answer is yes, you can change it. Will employees be resistant? Sure they will. If your employee base are people who are over 50 years old, you have to question, well, where else are they going to go? They may not have a choice. How else can we sweeten the pot to achieve our goals here? But you should never, ever make changes in a policy manual without notifying your employees prior to the start of that change. Technically, You could write a manual and not tell them, but how are they going to be bound by that? The bad will that will be created is so overwhelming, it is not worth even thinking of going there. When employees, you have to face hard choices, and a lot of practices need to do that, a lot of businesses need to because of the economy and because of lots of regulations, including the Unaffordable Care Act and the employer mandate. You have to make those decisions. The best way to make them is in an inclusive manner. One of my favorite techniques, by the way, is actually calling team meetings and saying, we're going to have to do something tough here. Any suggestions from the floor? And then working accordingly. But if you have to make changes, employees should not be discovering on January 7th or 10th when they go to the doctor that their deductible has gone from $1,000 to $2,500. They're going to be very angry. So part of the way that you control your workplace is by mitigating employee anger. And notice is a very, very crucial part of that. Sure, they'll give you some lift, but you will face a lot more at the tail end if you haven't notified them properly. Also, I just have found historically that a company that doesn't have its manuals, its memoranda in order, in a place that's accessible, clear, written appropriately, tends not to keep good records either. So they go hand in hand. And I cannot tell you how often cases are lost because of this. I just wrote a blog post that you'll be reading in a couple of weeks in which if you do not know how to access your own documentation and 5 years down the road someone claims that there was discrimination in the workplace and the person she dealt with no longer works there and there is allegedly communication, but you don't have records of it, you don't have a file, your manual from that point in time has now disappeared into the circular file, you're going to be in big, big trouble. A scanner is a wonderful, wonderful tool. I do prefer employment documents to be in writing and signed in ink because that way there can never be an allegation that they were falsified. And when I write a manual, everybody signs and initials every single page. I call it commando management because that way they can never claim that you swapped that page later without telling them because the ink is going to match. And forensically, that's an important thing to do. But I think if you do have documents that are old, past 10 years, you may want to scan them just to have a historical reference point for your business. I see a great deal of assignments of people to do the human resources work in small businesses who have absolutely no understanding of human resources. In a medical practice, sometimes it becomes the doctor's wife, or it will be someone who was an MA who just had a better skill set than the rest and gets promoted into management. Well, you know, just because you call somebody a manager doesn't mean that they really are. There are many educational outlets for people to learn HR management, employee relations, compensation, benefits administration, and especially employee discipline. These are complex issues. You should not be going them alone. I always recommend that one individual be designated as the in-house HR support and report person, and that person is the individual who speaks directly to legal counsel. Having counsel support is a very, very important thing. It is not terribly expensive. Every time I have to deal with an audit or a litigation, I can tell you that the bills are 10 and 20 times higher than when I get 15-minute phone calls from people saying, can you answer this one question, and maybe a little bit more. We go from $100 into the thousands of dollars. And we go from maybe a 15-minute discussion that enables you to run your business more effectively into a massive time killer and anxiety creator for businesses. So it's important not to go it alone. The stuff is so complicated now that even general attorneys are not capable of dealing with these issues successfully. And what are those issues? Well, one of my favorites, frankly, is misclassification. I'm one of the leading experts in the state on classification law. I've tried more cases of classification than any judge in the state in the last 5 years. This is one of the most complicated areas of law because if it isn't bad enough to understand the difference between an independent contractor and an employee, the crazy part is that different standards apply. The definition of an employee for the IRS, FICA, Social Security, and Medicare is different than the definition that the federal government places on it for the purposes of Title VII, which is the Civil Rights Act, the Americans with Disabilities Act, the Older Americans, the Discrimination Act Against Older Americans, the Fair Labor Standards Act, the Family Medical Leave Act, and ERISA. And then we take the states. And the state law, in terms of income tax, workers' comp, and disability, believe it or not, differs from the state law as to unemployment insurance and discrimination. So when someone says, I think I've classified properly, well, if you picked one of those standards, one of these 4 groups that I've articulated, and you think you have, it doesn't mean that you aren't in violation of the other 3 groups. Obviously, they all have consequences. Is this craziness? The answer is categorically yes. It is ridiculous. There is no reason other than dysfunction of government and people not speaking with each other and coordinating, except for enforcement, why an employer should be in these conundra as to what constitutes an employee versus an independent contractor. Recently, I consulted for a client, and honestly, in the consultation, I pulled out the IRS 20-point standard. And we went through the standard, and that client, clearly, for IRS purposes, I think giving him the benefit of the doubt, he only reached 7 factors out of 20 that would lead to covered employment. So that was pretty good. Then I pulled out the Department of Labor standards, and under the Department of Labor standards, it was unquestionably employment. Now, you may say to me, well, that's great. Can I declare the person for the IRS as an independent contractor, but then for all these other purposes make him an employee? And the answer is no, you cannot. Person's either a 1099 or they're a W-2. There's only one case to the contrary recently, and it involved somebody who had 2 disparate job descriptions in the same organization. So he was a DJ, and then he also sold advertising time on the side. And they were completely different. That case wound up going through the tax courts into the federal court system. I guarantee you that it cost more money to deal with that case than this guy's entire income for 5 years. So not worth it at all. The IRS is based on common law agency principles, and so basically the question is, you have the right to control the person, and if you do, whether or not you exercise it, then that can be an employee. The common law, by the way, is the default unless you have further statutory intention. However, we do have further statutory intention in terms of all these other statutes that I've mentioned. The test most commonly used in New York right now is called the ABC. And in the ABC, the only way that you're not an employee is if there's documented absence of control, and it certainly helps to have a contract to show absence of control, and the acts of the putative employee are outside the usual course of business. If you're a medical practice, what I'm trying to tell you then is that any doctor who works for you, any nurse, any PA, receptionist, physical therapist in all likelihood, you're dealing with employees. A dentist, the hygienists are employees. The fact that they may work for other individuals some of the time, that means that they could be employees of 2 different employers. Do not fall into the trap of believing that that makes them independent contractors. If one dentist rents a chair to another dentist, then we go through an entire rigmarole as to whether they are independent, who takes the money, who books the appointment. And it can be very, very tricky, but the states are going after this like crazy. If you are in the medical professions, you are a sitting duck right now. They know that you're not going to pick up and leave, Governor Cuomo has announced some tax initiatives this morning that are supposed to help businesses. Believe me, they're not going to help doctors and dentists because they know you're not going to go to another state. You're bound by your license, and you have your clientele here. The other thing that we look at is whether the act of the independent contractor is something that they customarily do in their own business or profession. So that's called the ABC test right now, and that is the test that's focused on in many jurisdictions. Massachusetts and California have gone even crazier. New Jersey attempted to implement a stricter test recently, and the legislature passed it. Governor Christie vetoed it. But we are seeing this in every state in the country now because this is a revenue producer, and that is what it is all about. Let me just mention now, and I apologize for not mentioning it earlier, if you have any questions for me, you can type your questions and send them, and I will either answer them during the webinar or I'll answer them at the end of the webinar for you. So the other thing that I see businesses making terrible, terrible mistakes about that are subject to recent audits, relatively new audits, is the difference between an exempt and a non-exempt employee. Under federal law, there is a white-collar exemption. The white-collar worker must make a minimum of $455 per week, and then his duties must be either executive, professional, or administrative. Well, everyone understands that the CEO and the COO are executives, and we understand that a doctor, a lawyer, teacher are by statute professionals, but what's an administrative exemption? This is the tricky one. If you supervise more than 3 people, 3 or more people, and you devote 80% of your time to supervising their work as opposed to doing your own, that's the administrative exemption. That means that if you have someone in your organization who you pay on a weekly basis, not on an hourly basis, and that individual basically works half the time at her own function, maybe she's the biller, but at the same time she supervises all your receptionists, that's an hourly worker. If you don't pay them hourly, it will come back and bite you in a big way. There is a very, very big difference here. There are advantages to being a weekly worker. If you're an exempt worker and you come to work at 9 in the morning and at 11 you leave to go to a doctor's appointment and you don't come back the rest of the day, you may not be docked pay. That's the notion of being white collar. So that's a great advantage of being a white collar worker. Downside is white collar workers do not get paid overtime. They're not entitled to time and a half. Upside is that if business is slow, they get their full salary anyway, even if they're not doing very much. Whereas the hourly worker, you can cut the hours and therefore save yourself some money. A lot of employers are doing that now. And the problems that I see come at the end of employment typically. When employment ends, someone says to themselves, you know, I was never paid time and a half. Well, why didn't you say something during your employment? The answer is I didn't want to instigate the boss. Maybe I get fired. All right? So they wait till the end, and then they report you to the State Department of Labor. State Department of Labor steps into their shoes, and the State Department of Labor will audit you. That will cost the worker nothing. In other words, they could get a lawyer and sue you, but they don't really have to because the state will do their dirty work for them. This is arising now heavily in terms of housekeepers, live-in help, nurses' aides at home. And there have only been 2 cases litigated in New York on this. I had the 3rd one with the Department of Labor in 2013. And if you have someone who lives in your house and works basically as a nanny, and you don't have records every week of the hours they actually clock in and clock out, they can tell the Department of Labor that they work 24 hours a day. And frankly, if you figure out that 16 of those hours are at time and a half, and that the state will presume that whatever weekly salary you pay them was based on a 44-hour week, all I can tell you is that somebody who's making $25,000 a year is suddenly going to be able to collect $100,000 in fines. And the state will get more out of them, too. So this is very risky business. It can produce tremendous revenue for the state in terms of penalties. I I find that if you do not understand this and you don't invest in an internal audit or an external auditor review, which takes basically less than an hour of discussion with a lawyer, that employers are making this mistake over and over and over again. It is probably, besides classification, the most costly mistake that you can make. And now the state is onto this as a revenue raising technique. As a matter of fact, what they are doing now is that they are targeting certain industries. And when they do that, they've gone after the body shop industry, housekeeping, hospitality. They are looking at doctors' offices heavily in terms of the LPNs and the MAs who work more than 40 hours a week. There are definite target industries that are involved, but all it takes, and this is the key, to get in trouble on classification or on exempt, non-exempt, is for one person to file for unemployment. One person leaves your employ. They decide that they can't stand 6-degree weather. They've had it. They're moving to Florida. Or they get a divorce. Or their husband gets transferred and they say, I really am sorry to give up my job and I'm going somewhere else. And then they apply for unemployment. And in the unemployment interviews, now they're starting to ask questions that are tangential. And if the Department of Labor gets an answer that they think, oh, this is interesting, you're going to get referred and you're going to find an audit and think, but I was so good to the worker. I even gave her time off that I didn't have to when I paid her. I gave her severance money that she wasn't entitled to at the end of the employment to help her with her move. Guess what? It's not going to help you at all. And that raises another issue, by the way, which is discriminatory treatment or not treating everybody the same. Let me see, there is one question here. Let me see if I can answer it. This is Yvonne. Can a salaried employee who does not supervise anyone be docked if they leave early on a given day, or do they need to make up the time? Okay, so my first issue, Yvonne, would be, what does this salaried employee do? If they are not in a profession and they are not an executive, well, then they shouldn't be a salaried employee, period. So now we've got a misclassification. Assuming that they are in one of those categories, if they need to leave early, they may not be docked, and they cannot be forced to make up the time. Now, if you have workers who do that all the time on you, they're constantly cutting out early, you know the type, you go in and you see the sweater at the back of the desk like you think they're there, but they're not, they're gone. Well, then you're dealing with a disciplinary situation. Why did you leave early, Mr. Employee? They've got to give you a good reason. If they have an important reason, you want to document that. If they're walking out early at 3 o'clock instead of 5 days a week, and they can't give you a reason or documentation that is acceptable, then you need to move into progressive discipline. You need to warn them, document the warning, and then make a decision over time as to whether that employee has value to you. Now, I say this with a caveat because we have recently what's happening in this particular arena is that we are hearing from employers that the employees are raising health issues. They're saying, well, I might be covered under the Americans with Disabilities Act or the Family Medical Leave Act. Know that under the Family Medical Leave Act, there is something called intermittent leave, which means that someone has to leave early every day because they need to have dialysis or they need to have some other medical treatment, and it's for a disability, all right, then they are actually going to be entitled to do that, but they can't just do it on their own. They would have to apply for FMLA. To be entitled, they would have to work for you for at least a year. There's a minimum number of hours they have to work as well. And then you would go through the documentation process in determining whether or not to grant such a leave. So that's a very, very important thing to know. Under the ADA has expanded the definition of disability this year. The EEOC is going to an extent that is unworkable for employers. If an employee says, I'm stressed, I have to go at 3 o'clock every day because I just can't take it anymore. If that definition of stress fits into what's called the DSM, which is the Diagnostic Manual of Psychiatric Diseases, and they can establish that they have been so advised by a physician, you're going to be stuck or you're going to face liability under the ADA. I know that as a working business, this sounds crazy. It is crazy. What do your other workers think? That this one gets to claim every day that they can leave early because of a disability. Maybe they should all have disabilities too. Maybe we should all close our offices by 2:30 in the afternoon because our workers are too stressed out. I'm not sure where the end point of this is. I wish I knew. I think that if the administration thought about it in a practical sense and thought about what would happen if in the Department of Justice and the Department of Labor every other worker decided to do this, maybe we would have a slightly different resolution here. The same way that the Affordable Care Act might have been different if they had thought about the consequences of what was going to happen down the road with it. But I just wanted to point that out to you. Someone else is writing in, what if a physician's practice, the patient's schedule falls apart with cancellation and you send the person home? Is it against the law? Great question. What does your manual say? Does your manual give you the permission to send workers home during the day? Now, if you have low-level workers, they're going to be hourly workers. In New York, if you bring a worker in, you have to pay them for at least half the working day. And technically, they're entitled to the time for lunch. That's unpaid time. But if your manual says if we send you home early, then you will be paid the higher of the hourly rate or X dollars, yes, you can send them home early and cut their pay. What I advise employers to do in the physician's schedule then is define the worker. If this worker, and this is where the Affordable Care Act gets crazy, because the Affordable Care Act looks backwards and says how many hours did the person actually work in the previous 6 months or a year. They don't even know how they're going to run this thing, frankly, because there are different opinion letters and they're conflicting with each other right now. But for your purposes, if you designate somebody as being a full-time 40-hour-a-week worker, paid on the hour, and you start sending them home a lot, what may happen is that they're going to fall below the threshold to be entitled to be covered under your health insurance if it's an employer plan. They may lose other benefits, including accrual of vacation. So think carefully about it. I typically advise physician practices to set a base schedule and then to say that you're entitled to add to that schedule subject to need. And do it a week in advance. Don't do it the day of and send them home and try to dock the pay. Look at the schedule in advance. Statistically, you know how many people tend to cancel. Have extra work lined up. Cross-train your people. If somebody is cross-trained and the patients aren't coming in, then you should be able very, very easily to say, okay, the patients aren't here now, but we're going to do something else with you for the rest of the day. Someone else is writing, if someone's available via phone to the company as a technical support only when we need them, is he an independent contractor or an employee? That's a great question, Tara. What I would look at, and you can give me a call and I'll go through the specifics with you, what I would look at is he in an independent business? So does he provide that same tech support to a bunch of different businesses? If he does, then I'd be happier if you paid him, frankly, through a corporation that is an individual. It's not definitive to the Department of Labor, but it certainly goes a long way. I would want to know what the terms and conditions are. And Oliver writes, he's working for another employer in the same industry. He'll be getting paid for a set number of hours a week, whether or not he helps my staff. You know, if you have someone on call that way, and you are paying almost like a service contract, then what I would want to see is a document that says this is a service contract agreement between Oliver Corporation and Ruth Corporation. In consideration of X dollars, you will be available to me as a corporation. Now we don't count hours at all. We have a support contract. So I think that you should know that the euphemism and the wording that we use is very important. And someone's writing, last Friday the office was closed due to the snowstorm. Nobody came to work. What's our obligation, if any, to pay the staff? Great question. What does your manual say? I write manuals now that will allow an employer to make a decision to close for an extraordinary event. We started doing this after Hurricane Sandy, frankly. If you write that into your manual and you decide that that snow event was an extraordinary event, my recommendation is pay the workers for the day. Don't dock them. Don't make them unhappy. Be very gracious about it. I know that the holiday was the week before and you feel like they already had off. It's why are we giving them more time off? Sometimes that's a very good gimme to offer to workers so they don't feel like, great, now I can't pay my rent this month. But it doesn't happen all that often. It's like giving somebody leave if their parent dies and paying them for a few days. That's another thing that I like to do. When they read the manual, they feel like you're being compassionate. That's very, very important. But again, I can discuss all of these cases individually. If you work extra hours at home and physically work over 40 hours a week and want to take the time off rather than get paid, do we have to give them time and a half? Oh my God. I never ever let my clients do that, to swap out. Under the labor law, if they work more than 40 hours a week documented, you must pay them time and a half. You cannot swap them off with time for time that they did not work. That is Pandora's box. Tanya, don't do it, please. And then Lori is writing, we have in their manual, our manual, they must use their paid time off time. We give them all their paid time off at the beginning of the year, so that's a perk. I'm not a fan, Lori. If you give them paid time off at the beginning of the year and they take it and then they quit on you in March, boy, you've given them a very nice benefit. I don't recommend doing that. One of the things that I like to do is that I tend not to have sick leave and as a take it or lose it. Because what will happen is during Christmas they'll all get sick. You'll all get these fake coughs on the phone and think, okay, I know he's not sick, but otherwise he's going to lose the sick leave time. Then what happens? First week of January we have a flu epidemic in New York State. All right, now they have no sick leave time, and what do? They come to work sick. That's all you need. Now everybody in the office is sick, and now they feel, you know, that what happened last year was last year, but now I'm not getting paid because I'm sick, it's not there, and it breeds bad feelings. So again, I don't recommend doing that as well. Do you have to pay? Okay, this is another question. Do you have to pay if you were closed during bad weather? I think I've answered that one already. Let me talk to you a little bit about, let me talk to you a little bit about discrimination and harassment. Those of you who've had manuals written by me know that I not only include this in my manual, I also write a separate document about harassment and discrimination. It's very important that you understand the protected categories, that you can have an anti-retaliation clause in your manual. You must train on discrimination and harassment. If you do not, you are a sitting duck for plaintiff's counsel. I recommend that everybody be trained, including the management, and also that you not try to take the document and do the training yourselves, because that's where people get into a little bit of trouble. Another thing that's very useful is to train everybody together and then break out manager versus worker, because managers have different issues as to how they nuance their communications. Anytime you have a training, it needs to be documented. Now, what happens if the worker actually complains? Okay, you have to respond. Whether that complaint was directed to you, or you heard about it through the rumor mill at the water cooler, or you witnessed something, it's a complaint. You have to deal with it timely. You have to deal with it based on fact, not on emotion, and it needs to be documented. There should be a report, ultimately, memorandum to file. To avoid retaliation, you need to be very objective. Think about every negative employment decision. I highly recommend that if there is a complaint, that you do not go after one of the parties. If the complaint turns out not to be founded or it's ambiguous, please don't fire that worker for 6 months. Watch him or her like a hawk. But what you don't want to do is put yourself in a situation where a discrimination claim will be brought against you. Now, I mentioned before these issues of alphabet soup, the ADA, the Family Medical Leave Act. How do you handle the request for an accommodation? Well, we've got so many statutes that apply. Sick leave, which should be in your policy manual. Short-term disability, which is statutory disability, which you deduct 60 cents for every week of employment in New York. You may have a long-term disability policy. There's also disabilities based on workers' comp, a workplace injury, and then the EAP, which are employee assistance programs. Know that all these things work together. You can't just treat them individually. If you have a sick leave policy and your policy doesn't appear to run concurrently with short-term or long disability, there is a case recently that said that the individual was entitled to both. That's not great for the employer. So watch out for that. If you have a written policy that is comprehensive, it should say how to apply for the accommodation, where to direct the request, and what the employee's responsibilities are. Employees don't just get accommodations scot-free. If you need to see their medical documentation, for example, there's a doctor's note. If it's not in at the proper date, the request is simply denied. Now, there are privacy issues involved here. God bless HIPAA, because HIPAA is saying that you can ask for some information, but not too much. If you get something scribbled on a doctor's prescription pad that you can barely read, and it says patient sick, needs time off, no, that's not good enough. If they write the patient suffers from an emotional illness, what the government is telling us is it's none of your business, whether it's schizophrenia or bipolar depression or manic depression or an anxiety disorder or ADD. You can't go that far. It makes it difficult because without you really understanding the nature of the illness, how do you create the proper accommodation? So basically you have to be very low-key about it. You have to reassure the worker. You have to try to define what the potential accommodation could be. There is a rule called the undue hardship rule. I do not recommend that you go that route on your own. The undue hardship rule says that if the person's disability is such that you cannot accommodate them without imposing a tremendous burden on you, there are points where you don't have to. You should never do that, by the way, without the opinion of counsel. For documentation, leave documentation. Somebody goes on a leave, their leave should not be indefinite. The leave should say, the medical note should say, anticipated return to work date. It should acknowledge, by the way, that honestly, even though you can return a worker to a comparable job, unless there's an undue hardship, don't give yourself trouble. Return them to the same job unless you really have a good reason not to. And remember that you have to protect confidentiality. Someone is writing here, Lori, will you have access to the slides? And the answer is that if you would like access to the slides after the seminar, if you email me, and my email will be up on one of the slides, and I will tell it to you as well. If you write to me, I will have my associates send you the slides after the seminar is over. Now, as I mentioned, poorly written employment documents can really lead to trouble. So first of all, we want to make sure that your documents don't interfere with at-will status. Your documents should say the title, to whom the person reports, the duties, the starting date, the days, the hours, the classification, oops, I see a misspelling, salary, bonus, paid time off, benefits, eligibility, references, background checks, and it should honestly contain, if you have an employment agreement, a confidentiality and proprietary and non-compete agreement. I cannot tell you how often I get phone calls about somebody jumping ship and panic about the breach of confidentiality or non-solicitation, and then I read the manual or the agreement and I can't find a non-solicitation clause. So that you should think about before the fact, not after someone's actually stolen half of your practice. We see this a lot in medicine. There are limits to what you can achieve, but you have to at least write it and write it properly and have someone's signature on it. Background checks, very important. I've discussed this in various webinars. Please do not do your own background checks. Please outsource them to another company. The case law on this and what the government is telling us are two different stories. The government is now going so far, the federal government is, to say that if somebody's been convicted of a crime, and we're talking about a felony here, that you may not be able to take that into account in an employment decision, believe it or not. unless the crime was directly related to their job description. Well, as one doctor said to me on the phone the other day, you know, what does it matter if that person robbed a grocery store, let's say, and now they come to work for you 10 or 15 years later, and they have access to files that contain Social Security numbers. In other words, crime takes on new aspects now, thanks to technology and cybercrime and hacking, that it didn't 15 years ago. Why suddenly can't I take that into account? Well, there are ways, and there are ways, but legally this is what the administration is saying. This is because black men historically commit the largest percentage of crimes, and they are the largest percentage of the chronically unemployed. And that's where it's coming from. Is it workable in the workplace? Absolutely, absolutely not. But you don't want to do something in a background check that will put you at risk of litigation. Someone is writing, can you dock pay for the employee for coming late and leaving for a doctor's appointment or a personal appointment? In New York City, the answer right now appears to be no. Under the new statute, you may not do that. They're entitled to 5 days for those purposes. You would, of course, want in your manual to say that unless it's an emergency, they have to give you advance notice, and then you would give them a corrective action for failing to notify you in advance. Now, when you don't have job descriptions, when you don't develop your employees, and when you do not clearly articulate your goals and objectives, you don't do performance reviews, you don't put the warnings in writing, and you don't know how to terminate people properly, when you've mismanaged your end, expect trouble. So how do we avoid trouble? By having articulate job descriptions, by developing our employees, by making clear communication of our goals and objectives, i.e. it's unacceptable to come in late for a doctor's appointment that wasn't an acute emergency without telling us in advance so we could cover you, documenting it. When you don't give the warnings in writing, you're setting yourselves up. That person's going to get unemployment when you fire them, by the way. And let me add, and this is my pet peeve right now, that if you fire somebody and you don't get your unemployment questionnaire in within 15 days minimum, and there's a deadline, they're going to hit your account for unemployment and charge your experience rating for the next 5 years, even if that employee is held ineligible for benefits because of misconduct. If that makes sense to you, it shouldn't. The only reason for that is revenue raising on the part of the state. That means that if you use ADP or one of these services, or what's really scary is you close down for 2 weeks over Christmas because business is dead, you come back, you open the mail, you're past that 15-day limit, okay? You're going to pay whether you should or not. All right, so I don't want to get into the ethics of whether it's appropriate. It's not. It's terrible. But just know that that can happen to you. Now, it's very important also for you to understand one of the leading mistakes made by small companies is not managing technology and how the employees use it. Your document should address what is a valid business use, what's a valid personal use. Your document should say that anything that's on your server with your email address on it, at kirshenbaum.com, for example, it belongs to the employer, and therefore I would have no expectation of privacy except to the extent required by law. In other words, if you use employee email, there's a case in which someone used the employer's email to write to their lawyer about their sexual harassment claim, all right? And there's attorney-client privilege that actually applies to that communication, and it trumps the employer's ability to use the document. Other than that, it should be clear that you can monitor your employee's email and that usage can't be unoffensive. And again, this also goes to solicitation and license and copywriting, that they can't use the email to forward your whole client list to a third party. It's very important that you manage technology. There are problems with this, of course. There are always problems. And the problems are realistically people who use their email. They really do. And so it becomes a question of degree. I tell all my clients, please do not communicate with your people using text messages. Texts disappear from the system within 2 weeks. You cannot use them. Also, be very careful, because if you write something in the heat of passion that's nasty or harassing to your employee, or you admit that you did something wrong in writing and counsel doesn't see it, and then this arises later, you're going to be in trouble. I have great stories about the use of emails. My two most famous stories involve penises. I'll tell them to you on the phone individually. You will be rolling in the aisles, except it's not funny. It really is tremendous exposure, no pun intended, for the employer. The law on social media is so confusing right now, none of us know what it is. The Fifth Circuit, the Fourth Circuit, the Second Circuit, and the Ninth Circuit all disagree with one another, which is great. This means that all these issues will get to the U.S. Supreme Court very, very soon. But in the meantime, be careful, because some courts are holding that the employee has the right to protect their Facebook account. You may not ask an employee or potential employee for their password and user ID so that you can see what they are doing. The more interesting issue, by the way, is LinkedIn. What happens if I list myself on LinkedIn and I have LinkedIn connections, and now I notify everyone on LinkedIn that I've gone to another company? I don't even notify them. I change my profile, and LinkedIn does it for me. I can't stop them from doing it. Does that violate an anti-solicitation or non-compete clause? That is undecided law. It actually, I have a client who has this issue going on right now. It's very exciting legally, and it's very scary legally. So I just want to point that out. Severance pay, do not ever give anyone money at the end of their employment without calling me. Because if you give one person a nice benefit here, you may have a claim for disparate treatment under Title VII by another employee. Also, there is no reason ever to give severance without getting a release for that employee. And never pay severance in a for-cause situation. If you have a reason to get rid of that person, they had their hand in the till, they harmed a patient, just that's it. No exceptions. Patient harm, you'd be really shocked at what the courts are doing in these cases, by the way. In many cases, they're saying it's inadvertent. So the patient almost died, big deal. It's really ironic that the licensing boards and the Department of Labor are certainly not on the same page. So you really do need to check with counsel. Don't rely on what you know for health law, because employment law may be different. So in conclusion, almost everything I'm telling you about we can avoid with the assistance of counsel, by training, by strategic planning, and by not jumping the gun. Please, I know that there's a tremendous desire to resolve an issue quickly. 10 minutes on the phone can save you 100 hours in a courtroom. The last slide has my contact information, so I'm going to put it up. If any of you have questions for me that I wasn't able to answer here, please feel free to call me, and I will try to help you out. I hope that this was informative. If there is a subject that you would like me to present a webinar on in the future, please let me know. I have done one on embezzlement recently, and I have done a general one on employment law, but I would be glad to focus on any particular area that my listserv and my clients feel would be of value to them. So I want to say thank you for participating. Please, everybody, stay warm and stay safe in this horrible weather, and all the best for a happy, healthy, prosperous, and hopefully calm New Year with as few employment problems as possible.